Let's prepare to begin, please. Good morning. My name is Felicia Orth. I'm a hearing officer appointed by the Water Quality Control Commission to conduct a hearing in WQCC 23-84. We are at the 9 o'clock public comment session on day 5 of the hearing. This is the 9th of 10 public comment opportunities this week. The final opportunity this week will be at 1 o'clock this afternoon. In the event we continue the hearing to finish it on subsequent dates, there will be subsequent public comment periods, but we don't have that scheduled just yet. So I have 7 names this morning of folks either in the room or on the platform to offer public comment. Just a few guidelines. I will ask you to swear or affirm that you're telling the truth. I will ask you to spell both of your names for the transcript, and I will have to limit oral comment to 3 minutes. In the event you have more to say than can be fit into 3 minutes, please submit that comment in writing to Pam Jones. All of her contact information is in the hearing notice. So let's start with Emily Bradfute. Ms. Bradfute? Nope. All right. If she rejoins us, I will take her comment. Mary Whiteman? Please unmute yourself if you can. Mary Whiteman? No? All right. Will Athis? Will Athis, please speak up if you're on the platform with us. No? Chad Ingram.
Good morning.
Oh, terrific. Mr. Ingram, do you swear or affirm to tell the truth?
I do.
And if you would spell your name for the transcript.
First name C-H-A-D, last name I-N-G-R-A-M.
Thank you. I'll start your time now.
Good morning. I appreciate you giving me some time this morning. As I said, my name is Chad Ingram. I'm a resident of Carlsbad. I also work for the Carlsbad Chamber of Commerce. I'll keep my remarks short. I just think that appropriate and safe water reuse is crucial to water conservation, economic diversification, workforce development, and opportunities. Our state, we are not overly abundant in water, and I think that any opportunity that we can have in order to reuse water, I think is a good move. So I appreciate the time, and thank you again.
Thank you, Mr. Ingram. Chloe Henson. Chloe Henson, are you with us? Please unmute yourself.
Yes, I'm here.
Oh, hello. Ms. Henson, do you swear or affirm to tell the truth?
Yes.
And would you spell your first and last name for the transcript?
Chlohенson.
Thank you. I'll start your 3 minutes now.
Okay. Hi, thank you for this time. My name is Chloe Henson. I was born and raised in New Mexico, attended UNM, and currently live in Albuquerque, working with the Climate Justice Alliance. I'd like to demand a clear and effective rule that prohibits the use of the reuse of produced water off of the oil field. There needs to be a rejection of the reuse of dangerous and toxic produced water while thinking about how to phase out its production in the first place. As climate change worsens and our water becomes a more and more threatened resource, it's irresponsible for us to be implementing rules that would further endanger our water and environment. Wastewater from oil and gas drilling can contain PFAS, radioactive compounds, waste materials like arsenic, lead, benzene, and other toxins. Experimenting with it, especially off of the oil field, could lead to unforeseen and irreversible consequences. It would be difficult, if not impossible, to remediate land and water that's been contaminated by radioactive, toxic, and carcinogenic wastes. 2023 saw the hottest year in 2,000 years. Climate scientists are saying there's a good chance that 2024 could top it. We don't have time to experiment with new ways to reuse water from oil and gas drilling. We need to be thinking about how to phase it out in ways that are just for communities and workers. It'll be a complex process, and we can't afford any longer to pursue dangerous distractions like the one that would be allowed under this rule. Thank you.
Thank you. Jackson Kinney?
Yes, I'm right here.
Oh, hello. Do you swear or affirm to tell the truth?
I do.
Would you spell your first and last name?
Yes, first name is Jackson and last name is Kinney.
Thank you. I'll start your 3 minutes.
Good morning, everyone. My name is Jackson Kinney, and I'm a resident of Hobbs, New Mexico. My wife and I are lifelong residents, as well as our parents. And I support the use of treated produced water for industrial use because it preserves our fresh water. And, living in a desert, it is super hard to find not only fresh water, but just water in general. So thank y'all so much.
Thank you. Bob Wesley? Oh, there you are. Can you unmute yourself?
Thank you.
Oh, hello.
Uh,
Do you swear or affirm to tell the truth?
yes, ma'am.
And if you would please spell your name for the transcript.
Bob, B-O-B, Wesley, W-E, 2 S's, E-L-Y.
Thank you very much. I'll start your 3 minutes now.
Thank you. Mr. Chairman and Commissioners, my name is Bob Wesley. I'm a retired physicist and systems engineer and past president of the Water Advocates for New Mexico and the Middle Rio Grande. In light of the climate-induced reduction in surface water availability, and in light of the dwindling mined aquifers in many portions of the state, reuse of that large quantity of produced water sounds like a great idea. However, there are at least 5 big prerequisite ifs, none of which seem to be politically, technologically, or financially capable of being met in the near future. If number one, if we know what each and every chemical constituent in the produced water is or might be expected. Number two, if NMED has a scientifically based standard level of safe concentration for each of those constituents. Number three, if we have the technology at scale needed to reduce the concentrations below those standards. Number four, if nuclear radiation shielding is sufficient to protect the cleansing system operators. And number five, if NMED has the capacity and political direction to verify the ongoing success of the cleansing technologies. Commissioners, if you allow reuse at all of produced water outside of the oil and gas industry, please ensure the resulting rule set requires compliance with every one of the big ifs I mentioned. And for the record, I'd like to say that contrary to Mr. Hightower's reported testimony, to my knowledge, the Water Advocates, previously the Water Assembly, has not been involved in designing any produced water reuse public acceptability survey. Thank you for considering my input.
Thank you, Mr. Wesley.
Thank you.
Will Athis?
Yes, thank you.
Hello, do you swear or affirm to tell the truth?
Yes,
And would you spell your first and last name for the record?
Will, W-I-L-L, Athas, Athas.
Thank you. I'll start your 3 minutes now.
Thank you. Good morning, Commission. I'd like to thank all the Commission members for their time and effort this week on this critical issue. I'm a retired UNM professor of public health, a former health department employee, a doctoral level epidemiologist, and a longtime teacher of environmental public health. I have experience conducting disease surveillance and community health studies, as well as human health risk assessments in support of regulatory decision-making and risk management, issue at play here. It's safe to say I spent a good part of my career dealing with legacy environmental contaminants, PCBs, dioxins, organochlorines, heavy metals, and now PFAS. How many fish advisories are currently active in New Mexico? What are the long-term environmental and health consequences of PFAS? These are important questions. I try to teach my students that we should learn from our past environmental mistakes in order not to repeat them. So let's be clear, the proposed rulemaking is seeking to set the stage for a widespread environmental release of a toxic alphabet soup of chemical and radiological hazards. As the department correctly recognizes, major gaps in science preclude determining safe levels, if any, for release. Industry proponents have cherry-picked a handful of acute toxicity studies and proclaim that current effluent and water quality standards are sufficiently health protective for chronic long-term exposures. However, NMSU researchers in a 2022 peer-reviewed paper caution that toxicological study of produced water is in its infancy, especially in regards to synergistic toxicity. The industry has no clear understanding of the toxicity, composition, and variability in produced water, in part because they continue to hide behind an outdated federal rule exempting disclosure of proprietary fracking chemicals. They would have the public believe that an effective compliance monitoring program can be achieved without disclosure of past, current, and future fracking chemicals. Really? To me, that sounds like an environmental mistake just lying in wait. A 2024 paper in the Journal of Environmental Management estimated that 10.4 billion pounds of fracking chemicals were withheld as trade secrets nationwide between 2014 and 2022. Moreover, proprietary claims are increasing over time in mass, frequency, and proportion. What persistent, mobile, and toxic fracking chemical might be introduced in the future that slips under the regulatory radar? If New Mexico truly wants to be a leader here, prudence demands that industry be required to disclose all fracking chemicals as a threshold condition prior to adoption of any new health and safety standards, and certainly prior to writing any discharge permits. Why should profit-driven business interests take precedence over the public interest? Thank you for your consideration.
Thank you, Mr. Athas. I've come to the end of the list that I have of people who reached out to Pam to make a comment this morning, but I'm happy to make an open invitation to anyone on the platform or in the room to offer comment before we return to the technical case. There will be one more opportunity today at 1 p.m.
You don't have to. You don't have to. I'm gonna try.
Oh, is this, I saw a name. Who was that?
Hazel?
Oh, yes, terrific. Hazel James. Do you swear or affirm to tell the truth?
Yes.
And if you would spell your first and last name for the transcript.
HAZEL JAMES.
Terrific. I'm going to start your 3 minutes now.
Yes, good morning, everyone. Yacht A. My name is Hazel James, and I'm with the San Juan Collaborative for Health Equity and Diné Centered for Research and Evaluation. I'm here as an individual, as a grandmother and an aunt and sister and a matriarch. And my comment to this water issues pertaining to produced water, and which also evolves the air that we breathe, is not a good thing to talk about, to utilize this radiated water for any other purposes. The industry has left this wasted water, and we're talking about how to use it. And we cannot use it in any shape, form, knowing the fact that we are under climate change, knowing the fact that it has ruined the land space and the landscape that we have out on Navajo land. The lands are beautiful out there. The air is supposed to be beautiful too, but we don't know the content that's in the air. But we do know that it's not good. So there you are. You have to listen to the elders that are speaking for the earth. We have to know that the water is sacred. We also have to know the air comes with the water and the earth. The way Native Americans, you don't have this knowledge as the lawmakers. The natural law exists as it is. And the water is the thinker of the earth. And the water has to be clear for people to have a clear mind and clear spirit and good health. Is there something in that situation of understanding is not being communicated correctly for you to understand? How much further does Indigenous people have to continue to voice for the earth, to voice for the water and the air and the sun, our creator? Why are we taking this so much further out? Why do we want to abuse the land, the earth, the water? We need to have some control. As you know, the world is destroying by the second. As you know, there's Native Americans that believe that if we do not stop this catastrophe, it's going to hurt your unborn children. Right now, we have 19% of uranium and the babies are being born because of open pit mines. The industry is really unaccountable and unequivocal to what they are doing to the people. It's awful. So this
Ms.
is,
James, would you wrap up, please?
yes, but this is my concern. And that's why I come before you. Please listen to the people and the matriarchs. Yeah, thank you.
Thank you, Ms. James. Rebecca Sobel?
Yes, can you hear me?
Yes. Do you swear or affirm to tell the truth?
Yes, I do.
If you would spell your first and last name for the record.
REBECCASOBEL.
Thank you. I'll start your time now.
Thank you. Good morning, commissioners. If oil and gas was going to make us rich, we'd be rich by now. New Mexico is the second biggest oil and gas producing state in the nation, yet we have the worst public education and the highest rates of child poverty and hunger. This is a state where Dene families on the Navajo Nation can live only 300 feet from a fracking well, but have no access to electricity or water. The push for produced water reuse is not just an issue for New Mexico. The decision that you'll make today in this hearing affects all downstream communities. Low income and minority populations are already disproportionately impacted by the health hazards associated with oil and gas waste. On Wednesday, Produced Water Research Consortium Director Mike Hightower testified that industry would, quote, give away this treated waste to water scarce Navajo communities. This is the first time I've heard this proposition to poison us for free. Still, no thank you, Mr. Hightower. We are at a critical juncture. The oil and gas industry has a stranglehold on our state politics, while frontline communities are fed up with being collateral damage. The United States is the world's leading oil and gas producer, and New Mexico houses the largest and cheapest oil field in the world. We're also the state where they tested the atom bomb, and we're still dealing with hazardous impacts and downwinders. Southeast New Mexico is home to Carlsbad Caverns National Park, Canyon and Karst Country, and this porous limestone is creating massive sinkholes and earthquakes with the incessant injection of oil and gas waste. Industry is literally running out of space to dump their waste, and now they're looking to offload their liability by commodifying it. In the poorest state in the nation, with the least amount of surface water, promoting a scheme to recycle fracking waste as water seems like a guarantee to perpetuate New Mexico's legacy as a sacrifice zone. There's been a lot of discussion about on and off oil field use. This distinction is difficult to ascertain. Currently, the oil and gas industry is leaking, spilling, and exploding its toxic waste across our state. In normal industry operations, this waste is piped, shipped, trucked, and dumped in landfills, endangering our communities and waterways right now. Already, millions of gallons of oil and gas waste are spilled over the surface of New Mexico each year. These spills are largely preventable, with equipment failure being the most frequently cited cause. Despite a distinct prohibition in 2021, oil and gas waste continues to spill recklessly, endangering communities, lands, and waters. Public comment every day has demanded an end to a perpetuation and impact of sacrifice zones. As we confront the climate crisis and transition to cleaner energy sources, it's imperative that we hold the oil and gas industry accountable for its toxic legacy. This means closing loopholes that allow for chemical secrecy, strengthening regulations to protect public health and the environment, and investing in alternative solutions for managing produced water as waste. I urge this commission to support an all-out ban on treated and untreated produced water, including removing provisions for industrial and pilot projects. Before we consider commodifying the oil and gas industry's waste and forcing it on New Mexicans, we must first prove that the industry can safely manage its waste on site. We cannot afford to unleash this toxic floodgate and irreparably poison our waters and future. Thank you.
Thank you, Ms. Sobel. Kathleen Burke?
Yes, ma'am.
Oh, there you are. Do you swear or affirm to tell the truth?
I do.
And if you would spell your name for the transcript.
First name Kathleen, Kathleen. Last name Burke, Burke.
Thank you. I'll start your time now.
Good morning, one and all. My name is Kathleen Burke. I'm a resident of Albuquerque. I'm speaking on behalf of myself and my household. I begin by sharing with you the definition and explanation of ecocide. Ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. This definition comes from the Independent Expert Panel for the Legal Definition of Ecocide, June 2021. The Stop Ecocide International Foundation provides further legal definition for each of the terms used in the definition of ecocide. A, wanton, means with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. B, severe, means damage which involves very serious adverse changes, disruption, or harm to any element of the environment, including grave impacts on human life or natural, cultural, or economic resources. C, widespread, means damage which extends beyond a limited geographic area, crosses state boundaries, or is suffered by an entire ecosystem or species or a large number of human beings. D, long-term, means damage which is irreversible or which cannot be redressed through natural recovery within a reasonable period of time. Ecocide refers only to the very worst harms, usually on a major industrial scale or impacting a huge area. Fracking and the distribution of its toxic byproduct are clear examples of industrial sectors and contexts where unlawful or reckless conduct could cause this level of harm. Ecocide describes what is happening to our planet, the mass damage and destruction of the natural living world. It literally means killing one's home. The European Union recently voted to include ecocide-level crimes in the European Union's revised crime directive. The historic decision will strongly reinforce existing environmental laws, establishing a clear moral as well as legal red line, aimed at preventing and punishing the gravest environmental harms. These are laws which our New Mexico lawmakers will also soon be considering. In light of the fact that we are now in the 7th mass extinction of our planet, the Holocene-Anthropocene extinction event, you might agree that laws preventing ecocide cannot be adopted soon enough in the United States, and we must pay heed to the crimes of ecocide happening in New Mexico preemptively. Referring to oil and gas workers exposed to radioactivity, Lawyer Stuart Smith, a New Orleans-based attorney who tried the cases and was the first attorney to try oil field radiation cases, says, quote, "These men are guinea pigs. I have litigated several cases that showed that oil field waste caused cancer," he says. "All the big majors have known about this for many decades. The
Will you
regulators are
wrap up?
obviously
Ms.
aware of."
Burke, would you wrap up?
Yes, ma'am. "The regulators are obviously aware of it too. It's just that they don't have the political cojones to do anything about it." Thank you.
Thank you very much. Thank you. Is there anyone else on the platform? Again, I have no more names of folks who reached out to Pam. Please speak up or raise your virtual hand there. I'd like to offer a comment. There is one more opportunity today at 1 p.m. No? All right, then. And let me just ask in the room, is there anyone here present to offer public comment this morning at 9 o'clock session? No. All right. We are going to return to the technical case. When we broke last night, we were still in the cross-examination of the department panel. Panel, if you would resume your seats there, and we will turn to Ms. Fox, who will be conducting cross-examination on behalf of Amigos Bravos and Sierra Club. Ms. Fox.
Thank you, Madam Hearing Officer. Good morning. Good morning, Commissioners. A little, okay. How's this? Closer? How's this? Okay, great. Good morning. Thank you for your testimony and your work on the rule. I'm going to direct questions to the entire panel unless I specify otherwise. Did you hear Mr. Hightower's testimony the other day that the consortium or researchers affiliated with the consortium had identified approximately 400 potential constituents in produced water in the Permian Basin?
Yes.
And Mr. Hightower compared that analysis to the Danforth et al. Study that has been discussed widely in this proceeding that identified approximately 1,200 potential constituents in produced water, correct?
Correct.
Has Mr. Hightower or the consortium submitted that study that he discussed or its results to the department?
Not that I know of.
Has he submitted anything at all in writing to the department about that study?
Not at this time.
The department, therefore, has not evaluated the reliability of that information, correct?
That is correct.
Are any of you familiar with ABSC Exhibit 11, the 12/9/20 letter from Dr. Danforth and colleagues from the Environmental Defense Fund that Dr. Lewis discussed in his testimony and that was admitted into evidence? I have a copy if that would be helpful.
That would be helpful. Thank you.
Are any of you familiar with that letter?
Yes.
Yes.
How is each of you familiar with that letter?
I received this letter when I was the Water Quality Standards Coordinator for the New Mexico Environment Department Surface Water Quality Bureau. This was a letter in response to a request for public comments on the amendments to the state's water quality standards in 20.6.4 during our last triennial review.
And I received a copy of it from Lowell herself at a meeting. And
Dr. Danforth.
Dr. Danforth, thank you. I'm sorry. And discussed it with her at that meeting.
So that letter has a list of 180 known produced water constituents that, one, have a standard approved analytical method that's currently available. Two, do not currently have numeric water quality standards in New Mexico. And three, have some toxicity data available. Is that correct?
Yes.
Yes.
In your view, is the analysis in that letter reliable?
I have no reason to object to it.
When we received the letter, we brought it back to the department and also had the spreadsheet associated with it, the actual raw spreadsheet, and we continued the work and verified as well as added to the analysis in it. Me and another previous staff member that was on the team drafting rules.
And have you ever had any conversations with Dr. Danforth about the contents of this letter?
Yes.
What was the nature of those conversations?
We discussed the process and methodologies, and I was asked if there was any elaboration that could be done on the data set to further the research.
Did you hear Mr. Hightower's testimony the other day? Am I echoing? Oh. About the survey that the consortium conducted with respect to people's views on produced water?
Yes.
Was the department involved in design of that survey?
The survey was designed through one of the working groups with the consortium, the Public Education and Outreach, which I attended the vast majority of meetings, and I assisted them in part in the development of the questions, and I suggested potential methodologies for them to collect responses.
That survey was conducted at state and county fairs and local water fairs and the like, correct?
To the best of my knowledge, that is the limited sample population that they chose to.
That survey was not designed to be statistically significant, was it?
My input into those meetings was very heavily in emphasis. I emphasized very heavily that it was important for them to diversify the locations that they asked the survey questions, and that in order to be significant and provide them with information they were looking for, that they would need to collect demographic information as well as information. The long and short, no, the results are far below where it should be considered to be statistically significant.
And Mr. Herman, have you ever taken any courses on statistics?
In grad school, I took multiple courses in statistics. I also was a research assistant on a large scale survey of Albuquerque residents that collected information on indirect and direct potable reuse support.
Yesterday, Ms. Taylor asked you about language in section 400A4, which reads, it's the last sentence in that paragraph, which reads, quote, demonstration projects or industrial projects submitted to the department through the notice of intent process and subsection C of 20.6.8.400 NMAC are authorized to operate following the determination of no discharge permit required issued by the department. Her line of inquiry had to do with why this language appears in section 400.A4, which relates to discharging treated produced water to groundwater, and not also in section 400.A2, relating to discharging produced water to surface water. Is that correct?
That is correct.
And her inquiry was, why is there a difference, since the demonstration projects can apply to both groundwater and surface water, correct?
Correct.
Now, it is clear that NMED's proposed provisions for demonstration and industrial projects at 400B expressly apply to groundwater and surface water, correct?
Correct. It does say ground or surface water.
And do you consider the proposed provisions at section 400.B authorized uses and C NOI requirements to be clear as proposed?
Yes.
Amigos Bravos and Sierra Club have proposed to delete the language that I just read at 400.A4 on the ground that it is unnecessary, correct?
I believe that is what Amigos Bravos and Sierra Club had submitted.
And they contend that the provisions at 400.B authorized uses and C NOI requirements are clear as proposed and do not need to be referenced in that particular section 400.A4, correct?
I believe that's what was proposed.
So would deleting the language that I read from 400.A4 be a way to resolve Ms. Taylor's concern that groundwater is singled out in that section, and Amigos Bravos and Sierra Club's concern that that language is unnecessary?
Could you read me the specific sentence that is being considered for strike?
Sure. Demonstrations, the last sentence in 400A4, demonstration projects or industrial projects submitted to the department through the notice of intent process in subsection blah, 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 are authorized to operate following the determination of no discharge permit required issued by the department.
I don't know that we would have strong objection to that. I believe that there is clarity in including the language following the determination of. I do see where authorized to operate could be misleading though.
Amigos Bravos and Sierra Club propose adding the following language at 400C3. And that is, quote, the department shall publish on its website all applications for produced water, notices of intent, supplemental information provided by the applicant at the department's request, all written procedures and plans required by paragraphs B and C of this section, and the department's determination. Now, the department currently publishes produced water notices of intent, supplemental information, and NMED determinations on the NOI on its website. Is that correct?
That is correct.
And why does NMED publish that information on its website?
In part to accommodate the transparency, the department does not have authority over the consortium's website, and we believe that the information being provided to NMED on these demonstration projects is valuable. And so we've taken it upon ourselves to publish it on our website just for simplicity and clarity.
Does the department intend to continue to publish this information on its website after this rule is promulgated?
To the best of my
If
knowledge,
and
yes.
when this rule is promulgated, I guess I should say.
Yes. I don't believe that the department has any objection to continuing the process we've already begun.
Then does NMED object to including this provision?
No.
Mr. Cox asked the other day whether the public is given notice of proposed demonstration and industrial projects under the proposed rule, correct?
Correct.
And I believe Ms. Murphy responded that under the current NOI process, some members or neighbors of projects are notified. Is that correct?
Under the current process that we utilize attachment B from our memorandum of understanding, that is included as a requirement in that document and is, yes, part of the process at this time.
What is the scope, the geographic scope, or what is the scope of the notification of members of the public at this point?
We would need to look up the MOU and attachments. It is NMOGA Exhibit 29, page 12 of the PDF, about the middle of the page, subsection T, that says provide list of all landowners adjacent to the proposed project locations and provide confirmation that adjacent owners have been notified regarding the proposed project, and then provide the source of the adjacent landowner data.
So adjacent landowners.
Yes, that would be the short answer.
Well, no, I appreciate you reading the full provision. Would NMED object to continuing that or a similar public notification process if and when this rule is promulgated?
We haven't had specific discussions about that being included. In general, I believe that NMED is not against the public being notified if they are next door to a project. So I would say, with my current knowledge in my brain, that we would not object to it.
Thank you. With respect to industrial projects, there are no volume limits on the quantities of produced water that can be used in those projects, correct?
Correct.
And there's no limitation on the concentrations of contaminants that can be used in that produced water, correct?
Correct.
And similarly, there are no time limits on the use of produced water in industrial projects, correct?
Correct.
Under the department's proposal, produced water can be used in industrial settings 24 hours a day, 7 days a week, indefinitely, correct?
As written, correct.
Really the authorization for industrial projects is an authorization for regular and routine use of produced water in industrial operations with no limits on volumes of produced water or concentrations of contaminants or time limits, correct?
I would like to clarify that the department would not be authorizing the project. The department would be making the determination that it is non-discharging and therefore not within the regulatory authority of the Water Quality Act.
And when you are reviewing that for the no discharge determination, your analysis doesn't include, there's no prohibition against the time limits of use, the concentrations of the contaminants, or the volumes of contaminants.
No,
Would you agree that industrial projects, because of their ongoing nature, potential for greater volumes, greater concentrations of pollutants, maybe less safeguards than in a lab setting, pose a greater risk of spills and discharge to ground and surface water than demonstration projects?
I couldn't speculate on that.
That analysis has not been done.
We have not done a calculated analysis of volume. Obviously, there is inherent risk with any project of any volume, of any concentration. So, scenario wise, if you have an industrial project and it has mechanisms in place using other state regulations, could it be more? Could it be less? A demonstration project is short in term and experimental and may not have the protections in place because they just don't foresee that. Whereas an industrial project may because they're looking at a long-term use. So that's why I don't feel that I could speculate on risk just based on volume, concentration, and time.
So that risk analysis has not been done.
Quantitatively, no.
Thank you. That's all I have.
Thank you very much, Ms. Fox. Before I turn to Mr. Knight, let me ask, I believe a commissioner indicated to me that he had another question. Yes?
Your Honor, can you hear us? Seems we may have disconnected. I'm not seeing yours.
Is there page limits on every?
Yeah, but it's pretty,
Pretty
they don't
loose.
care much about that. I had 6 days to resign to brief.
Okay.
And they don't grant extensions. Like,
Oh, yeah, it's still recording. Oh, it's still recording. Okay. Thank you for hanging in there with us during that technological interruption. Our screen here in the hearing room went black. So we're going to resume here. I was just inviting the commissioners who are the decision makers in this matter, if they had any final questions before I went to the department council for redirect of the department panel. Chair Thompson.
Thank you, Madam Hearing Officer and panel. I have just a few questions. There has been, over the course of the last several days, and specifically Council Tim Davis, or I've forgotten which organization, there was this long discussion about whole effluent toxicity tests, wet tests. Are wet tests required in any of the rules pertaining to surface water and groundwater?
Not for groundwater.
for surface water, wet testing is not required in the Water Quality Act. I do not recall if wet testing is required in the Clean Water Act, but it is in all of the guidelines for permitting and the permitting manual and implementation. It is not, EPA does not require wet testing on all permits in New Mexico, but it is a permit requirement in many of the EPA issued NPDES permits in New Mexico.
Thank you. That's consistent with my understanding as well. Will wet testing be required for effluent from any of these demonstration projects?
I think that's the
Madam Hearing Officer, Chair Thompson, after 5 days, I got it right. The way that the demonstration projects are being proposed, there would not be a requirement for any prescriptive type of testing. It would depend on the entity that wants to do the demonstration project and what they feel would be most effective. So it's not a requirement. We would strongly encourage it. Ms. Murphy has testified that the consortium has a guideline that includes a list of targeted analytes, the wet testing, and non-targeted analysis. So we would hope, in working with the consortium and these entities who want to do these demonstration projects, that they would follow that guideline so that we could have the most comprehensive set of data.
Thank you. That helps. And that leads into my next question. There has been a lot of discussion about the work that the Produce Water Research Consortium has done. But is that the only work that would be acceptable to the department? So for instance, if a private entity wanted to test their magic technology, could they do that?
Again, Madam Hearing Officer, Chair Thompson, it is the way that we've set up the role, and I'm going to lean on Mr. Herman as well to correct me if I misstate this. It doesn't require them to have to go through the consortium. We would appreciate it, and I think that it serves in everybody's best interest to work with the consortium since they are the hub of that data. But this would allow entities wanting to work independently to submit the notice of intent. There's no requirement for them to work through the consortium as it's written in this proposed rule.
Do you know of any, sorry, Mr. Herman, did you have any?
I support her answer fully.
Thank you. Do you know of any entities that have done their own testing independent of the consortium?
I would speculate that there may be. and there may be interest in the future, but I don't know off the top of my head. And
Chair Thompson, if I can, I believe I do know that UNM has participated in and has conducted research associated with produced water treatment.
Yes. Yes, a little bit. And I'm aware of some companies that were testing forward osmosis, vacuum membrane distillation, and some other types of advanced distillation processes that have not been mentioned here. And I would just leave it at that. But because I think there are a lot of companies that do have very promising technologies, and they should be encouraged to test those technologies if they can. It would be unfortunate if we required them to go through another layer of bureaucracy, being the consortium.
Agreed.
Thank you. Yesterday, Ms. Nasi asked the commission, I'm sorry, the witnesses, whether comprehensive characterization of produced water is needed. And somebody on the panel said yes. And I'd like to know, what do you consider to be comprehensive? That's a pretty loose term. What do you consider to be comprehensive characterization of produced water that would be the information that would be required to be submitted to the department as an NOI?
Again, Chair Thompson, I can start and then I'll punt it. We believe that the work done through the Produced Water Research Consortium is a very good start. It is a group, the Risk and Toxicology Work Group, worked for a couple of years. I believe this is in Ms. Murphy's testimony, to develop this list. They've termed it the NPDES Plus list, and it has a list of constituents. Again, targeted analysis, the whole effluent toxicity testing, wet testing, and then the non-targeted analysis. So at least we can identify maybe what some of those unknown compounds are, not the concentration, or at least know what may be in there. And I think that is probably the best place to start when we're talking about comprehensive. You're right. Comprehensive is all and everything, and that is quite an undertaking. But I think the work that the Risk and Tox group put together, which included NMED and EPA, is a very good place to start for what we would at least try to grapple with as the universe of constituents in produced water. And I would welcome anybody else in our panel to discuss that more.
No one else wants to weigh in? How many constituents are in the NPDES Plus list?
We can get you that
No,
information.
I can get it.
It is an exhibit. I just couldn't tell you off the top of my head.
So there's about 100 drinking water constituents identified in the Safe Drinking Water Act. And there's another suite of organics in the NPDES Plus list, but I don't believe there are any additional inorganics.
I would have to, it may take me a minute. I could.
No, that's not important.
Okay.
But I do think the department should give some thought to what comprehensive characterization. What a comprehensive characterization of produce water is required when an entity submits an NOI.
Noted.
There was Mr. Dodd yesterday had a long line of questioning about accidental releases. What agency regulates accidental releases of oil field waste in New Mexico?
Madam Hearing Officer, Mr. Chair, for accidental releases, if it's within the oil and gas production and industry, that's under the Oil Conservation Division and their rules set by the OCC. If it is outside the oil patch, it is NMED and it's 20.6.2, 1302, 1203. I always have dyslexia with that number. I apologize. 1203 in MAC.
And it's my understanding that Section 400 only deals with wastewater within the oil and gas industry.
Chair Thompson, I respectfully believe it's the other way around. This only deals with the produced water outside of the oil and gas.
Okay. So if there was a treatment process with the spill, that would be subject to NMED regulations, not OCD regulations?
That is correct.
Thank you. I've asked some of these questions before. Let's turn to municipal wastewater reuse. This is very short. The department already has guidance for non-potable reuse. So this would be land application, irrigation, and so forth. What is wrong with those current policies and guidance?
Chair Thompson, I believe this was in my oral testimony, but I can summarize it a little bit. Part of the issues that arise is, first, we have the guidance. NMED has a guidance from 2007. EPA has a guidance from 2012. The 2007 guidance for NMED is only one for domestic reuse, sources from domestic sources, and it is only for above ground reuse. As our world, and in 2007, when I started with the department, there were only a few discharge permits in which we're considering reuse. And now we have expanded by multitudes to have many permits. And so we've essentially outgrown that 2007 guidance. The other thing I'll point out is that although most of the language in the NMED's 2007 guidance and the 2012 EPA guidance mostly align, they don't always align. The last part is that guidances get updated without public comment, without public involvement, without public input. And given the number of municipalities that are using treated domestic wastewater for reuse in their parks and their public areas, I believe as a regulator that it's essential to put that, to grow into codifying these regulations. So I think we are at a time where using terminology that's gone through a public process and applying it in a streamlined way is really going to advance New Mexico with conserving our water resources, particularly with domestic wastewater. This is a reuse rule. And so there is a huge component of implementation that's regarding domestic wastewater reuse. And that's why the guidance is been outgrown, in my own terms.
Yes. Of course, as I've already said, I prefer the term municipal reuse because
yes,
much broader range of constituents. But so, for example, ASR, aquifer storage and recovery activities, where they're using treated wastewater, like Rio Rancho. Right now, that's not a full ASR project.
Correct.
They are just using just injecting into the aquifer.
Correct.
It's just aquifer storage and recharge. It's not reuse. But if they were to reuse that water, it'd be subject to two separate regulations. One would be the groundwater regulations, and then the second one would be the drinking water regulations. Is that correct?
That is correct. And they currently do have a discharge permit for the injection.
I'm sorry, I need to clarify that the drinking water regulations work much differently than the groundwater discharge regulations. And in conversations with the Drinking Water Bureau, and I'm only repeating what they said, so
Please.
is that they would regulate based off of source water, and they have internal processes. So it's just I feel a little bit less comfortable speaking for drinking water than I do for groundwater. Would definitely treated it differently.
Very familiar with drinking water regs, and I was gonna. This is my last question, and that is, we heard public comment from the mayor of Jal a couple days ago, and he expressed the sentiment, I believe, that his community would consider accepting treated reuse I'm sorry, they would consider accepting treated produced water as a source for augmenting their drinking water supply. And if they did that, would these regulations pertain, or would they be drinking water regulations that would govern?
Chair Thompson, again, I will start and hand it to Mr. Herman, who is currently exploring IPR and indirect and direct potable reuse potentials in the state of New Mexico. When it comes to using any treated wastewater for a consumable source, it will likely have to bridge multiple areas of authority and regulation. And as Mr. Herman stated, we can only speak to the groundwater side to protect groundwater for potential use in the foreseeable future. And then I believe that we would have to, and we have been engaging with other parts of our agency to make sure that there's that coverage. But again, we'll hand it to Mr. Herman and talk. But I think that's premature for this rule, but that is something that is in NMED's thought process at this point.
Yeah, and I will just add that at this time, we are grappling with the limitations in the Water Quality Act as they pertain to discharge permitting requirements that may apply or may not apply to a direct potable reuse scenario that does not discharge and that does not have any threat to groundwater. So it's on our long list of things to overcome.
I do want to make something explicitly clear. When we are talking about consideration of indirect and direct potable reuse, we are at this point in time only discussing and it's in the definitions of our proposed regulations. It would only be treated domestic wastewater, no other source, no industrial. There is no produced water for drinkable purposes.
And I my response, I forgot that you had asked it in the mayor's comment context, which that would not be contemplated by this existing rule, and we would follow the science as it became available to us and then make a determination at that time, which is my regulator hat response for you.
Thank you. I just, editorial comment, I guess, is the regulation is called water reuse. And so I would hope that it would deal with potable reuse as part of it, but we've talked about that before. Thank you. I appreciate it.
Okay. Thank you. Are there any other commissioners in the room who have unasked questions. Commissioner McWilliams?
Yes, Madam Hearing Officer and Chair Thompson, members of the panel, thank you for taking our questions. I believe it was a couple days ago that Ms. Taylor was questioning you about 74-6-15, which allows for the protection of confidential business records or methods or processes entitled to protection as trade secrets. According to the Water Quality Act, who would decide if this information was confidential?
Madam Hearing Officer, Chair Thompson, Commissioner McWilliams, I believe that if something were to be submitted to us, we would work with our Office of General Counsel to determine how to manage that.
Okay, so would the department know if that technology or the results is proprietary or trade secret?
No, the business is
Your Honor, this is Mr. Maxwell. We may have lost connection.
Okay, I had a question regarding the definition of produced water. It includes the words known and unknown water pollutants. And then the water pollutant definition, you know, if we go to the water pollutant definition, I believe it talks about causing injury to health in animals and livestock, all those things, plants. Wouldn't that be by definition make produced water something that we would have to change the definition for if it was ever going to be allowed to be discharged?
Commissioner McWilliams, we have a definition for produced water, which in and of itself is just a byproduct of the oil and gas extraction process. And it does, as stated in, I think it's the evidence that it has constituents that are water pollutants that would cause injury is ubiquitous among all produced. That is one of the things we were able to confirm with all the studies that have been submitted and that we reviewed. It is one of the reasons we put in a definition for treated produced water, because there is a very big difference between produced water as it is extracted versus a treated produced water. And I
Okay.
believe the definition for treated produced water does not, it depends on the level of treatment. It depends. So we wanted to make that clear that produced water is what it is, and it does have water pollutants, which therefore require a treatment. And treated produced water does not have that same description to it.
Okay, so you wouldn't have to alter the definition because produced water would likely never be allowed to be discharged, but treated produced water could be discharged at a later date.
Correct.
Okay.
As writing regulations, as much as I can set up the structures so that we don't have to have complicated amendments, I do my best to do that. So that's why we have those added definitions in there.
Perfect. I believe yesterday, Mr. Herman, you testified that a double-lined pit with leak detection would require a groundwater discharge permit.
I would respectfully revise that characterization of my testimony to say that historically the department has required discharge permits for double-lined synthetically lined impoundments.
Okay. Is that outside of the oil and gas industry?
Yes.
Okay. Thank you. That's all my questions.
Thank you. And the other commissioners in the room who have final questions, Commissioner Zemlich.
Thank you. I just have one last question, just to clarify from yesterday. There was a discussion of a sort of a large industrial project, and the concern over potential releases from something like that. And previously, and I'm not going to target anyone, your testimony, maybe Mr. Herman, the process of determining whether or not a groundwater discharge permit is required includes multiple scenarios, including perhaps the site, the material, and perhaps the volume, which in my mind goes some way to addressing risk. And so I just would like, I mean, maybe to ask if there is a threshold for that sort of volume in a determination like that, in your analysis of whether a discharge permit would be required.
I think that there's such a high variability in possible scenarios, even with the site specific things like geology and location and depth to groundwater, specifically for the groundwater side of the process, that it would be there would not be a threshold as a result of those highly variable. Is there karst? Is there basalt underlying the site? Is groundwater at 1,000 feet or 50 feet? And so we chose not to include a number in the regulations.
So, and to follow that up, so for excluding the effluent of the Alamogordo desal facility, would something like that as a demonstration facility potentially not require a discharge permit?
Yeah, could you clarify? So there's two brackish water facilities in Alamogordo.
Right, not Bergendorf. So, and I always just think of it as the Alamogordo desal plant. I think Mr. Hightower mentioned it treats 500,000 gallons a day. It's a fairly large amount of water. Should a demonstration project be proposed with, say, that volume, can you see a way in which that would not require a discharge permit?
I will take the opportunity to correct Mr. Hightower briefly. To my knowledge, and I believe my staff recently inspected the facility. The desal plant is not operational at this time. They have not processed or treated any brackish water. But if your question is couched with that site specific location and parameters, then I mean, I think we've already made a determination that a discharge permit would be required. Is there a scenario where someone could propose something in some way, shape, or form where we wouldn't require a discharge permit? We would have to review that on a case by case basis. I wouldn't want to speculate on what are all of the possible submissions that someone could come up with to send into us.
Okay, and would it be fair to say that a demonstration project with a large amount of proposed treatment volume likely require a discharge permit?
I would I wouldn't, I don't know.
Okay, and that's fine. I know it's a lot of hypotheticals, but when I think of big industrial types of operations, I usually think of the risk involved as being sufficient enough that the way that discharge permits have been characterized, that one would likely be required, but I won't ask you to answer that. And so my follow-up suggestion is just that the department consider the how the information about these NOIs is disseminated, whether it's a map-based sort of inclusion on the site where individuals can, without knowing what a township range is or things like that, be able to identify where these proposed projects are occurring, just to sort of facilitate informing the public.
Understood. Thank you.
Okay. Anyone else in the room have a final question? No? I know we have at least two commissioners on the platform, Commissioner Rosatos and Commissioner Brankard. Unmute yourself in the event you have a final question, please. Okay, not hearing anything. Mr. Knight, would you estimate your redirect, please?
Would I estimate?
How long your redirect is going to take?
I would say 15 to 20 minutes.
All right, we need a break. Let's take a break for 10 minutes.